I'm former prosecutor, now criminal defense lawyer Neil Schaus. And over the years, I've seen many cases where somebody is charged with shoplifting, but they did not intend to steal the merchandise, they simply forgot to pay. So maybe they're going to try on some clothes, maybe they're holding some electronics, they're planning to purchase it or at least look at it further, try it on, but for some reason they decide to leave the store. Maybe their kids are acting up, maybe they have to take a phone call, maybe they need to go get money from their wallet in their car, but they walk out of the store forgetting to put the merchandise back or forgetting to pay, but with no intention of stealing the merchandise. And those people there are not guilty. That is, they might be charged with theft in that situation, with larceny, but they're not guilty because they had no criminal intent to steal the merchandise. And I'll give you an example that we just had very recently at our own law firm. And that involved a client who was at the Macy's store at the Santa Monica Promenade. And our client had several articles of clothing that he was going to possibly try on. And he had these in his hand, and he was going to try them on, and he got a phone call on his cell phone. And he went to take the call, and he realized that he didn't get reception. He had no bars in the store. And so he walked outside of the store with his cell phone, basically to take this call where he would have reception. And unthinkingly, he just had the merchandise in his hand, but had no intention of stealing it. He got detained by loss prevention. The city attorney charged him with petty theft. We actually took that case to trial. And when the jury heard the evidence and our arguments, the jury came back and found him not guilty of all the charges. And he was exonerated and the case was dismissed. We've represented many people in this very situation over the years, and we've very often been able to convince the prosecutor or the judge to dismiss the charges, or if it gets as far as a trial, to convince the jury that our client is not guilty and ultimately get our client vindicated.